Amendment is defined thus: to make right, to correct, or rectify. In its judgment, the High Court determined what the basic structure is. And it is said that the basic structure entails the essential features, the core of a constitution. I purpose to hazard a definition of my own. It is the distinctive feature of a particular constitution. Now, remembering the definition of the word alter and amendment, what is the basic structure in our submission is that which can only be altered. And what is left for amendment is not the basic structure. An argument was made that this doctrine is emergent. Is it so? It is my humble submission that the doctrine is not emergent. John Locke, in his book, The Two Treatises of Law, defined what a basic structure is. Charles Montesquieu also defined what a basic structure is. Permit me just to refer to their definitions. You will find this in volume 1 of our list and bundle of authorities. Now, at page 241, a trichotomy of the systems of government is made. This is by John Locke. 1, there is a perfect democracy where the people elect those to make laws for them. 2, there is an oligarchy in which a few select men constitute themselves the leaders. Lastly, there is a man, unfortunately those days they were just rioting in the male gender, who constitutes himself the monarch with the succession to his son. Let us see what Montesquieu says about the structure. You'll find this at page 318 of volume 1. And it is subtitled, Difference Between the Natural and Principle of Government. He says this: there is this difference between the nature and principle of government. Nature and principle of government. That the former is that by which it is constituted, and the latter that by which it is made to act. One is its particular structure, and the other the human persons which set it in motion. Still on alter and amendments, because these are the identifying two elements of the basic structure, can we have a look at the path that the Kenyan people have traveled since independence? We will start with the Independence Constitution. I will call it the 1963 Constitution. The marginal note to section 20 provided as follows: alteration of this order. If you were to look at section 71 of that particular 1963 Constitution, it says, Parliament may alter any of the provisions of this Constitution, save for section 156. What did section 156 of the 1963 Constitution provide? It provided for devolution. It provided for an advisory commission, and it also provided for finances to be allocated towards devolution. This was the entrenched clause in the 1963 Constitution. It could not be altered. Sorry, it could not be amended. It could only be altered. Let us look at the 1969 Constitution. The mode of that change is found in section 47. Subject to this section, Parliament may alter this Constitution. And then subsection 5b, alteration is defined. References to the alteration of this Constitution are reference to the amendment, modification, or reenactment with or without amendment or modification of any provisions of this Constitution, the suspension or repeal. Yes, it may appear as if there is a conundrum, but as you consider that conundrum, that is the perception of what the people of Kenya have over this, which is otherwise a simplistic issue. Now, that dichotomy has been expounded further, and I will refer you to what is written by Professor Ben Nobweze on the same issue. Ben Nobweze, writing on the topic Presidentialism in Commonwealth Africa, the chapter on presidentialism and constituent power looks at the history of several African constitutions. He proceeds to examine, in particular, the Kenyan Constitution. And at page 527 of volume 2 of our list and bundle of authorities, he arrives at a conclusion demarcating the strict power of amendment and the repeal power. And he concludes, and if you permit me to read at page 527, this alternative method, that is amendment, that was used initially in Kenya appears to be legally unimpeachable, since the power to alter the Constitution was rather widely defined to include amendment, modification, etc. Then he proceeds. However, applied to the Independence Constitution, it may be doubted whether the spirit of the amending power contemplated the destruction through the superimposition of a republican presidential form of the system of government instituted by the Constitution, namely monarchical parliamentary government. The so-called amendment, in fact, established a new constitution and, as such, should have been effected by the repeal of the existing independence constitution. If there was any clarity that was required in differentiating between those two, perhaps I may look at a recent work on this issue, and permit me to refer to the book by Professor Richard Albert, Constitutional Amendments, Making, Breaking, and Changing Constitutions. Richard Albert, again, creates the difference between amendment and dismemberment. If I may refer the court to page 76 all the way to page 78, and at page 79 thereafter, Richard Albert sets out 4 fundamental aspects of what is in actual fact a constitutional amendment. He says there are 4 fundamental features to a constitutional amendment, properly defined: its subject, authority, scope, and purpose. He proceeds to define what dismemberment is at page 84. He says, This amendment is incompatible with the existing framework of the Constitution because it seeks to achieve a conflicting purpose. And note that that conflicting purpose will be bad. A conflicting purpose may still be desired and attained through this amendment. But what must not be lost is the manner in which those two elements, amendment and dismemberment, relate to the Constitution. Is the basic structure doctrine applicable in Kenya? The answer is yes. You've seen it from the writings of Professor Nubweze in the book I've just referred you to. In fact, Professor Nubweze refers to the Constitution in the following terms. Still on that book at volume 2, page 500, he says, a constitution is supposed to be a permanent charter which is to endure for ages to come and not to be lightly altered to meet the temporary expediency of party politics. Temporary expediency of party politics. Now, proceeding from that premise, the Kenyan courts have examined the applicability of this principle, and they did so 15 years ago. Sorry, I think it's actually 18 years ago. And this is the case of Njoya and others versus the Attorney General. And remembering what Professor Nobweze has written about the Kenyan Constitution, we look at page 688 of volume 2. This is what Justice Aaron Ringera, as he then was, said about those amendments we have just referred to in Nobweze. The effect of those amendments was to substantially alter the Constitution. Some of them could not be described as anything other than an alteration of the basic features of the Constitution. And they all passed without challenge in court. I will repeat the same thing I said here before the Court of Appeal. This time, they have been challenged. A determination has been made by the High Court. Another determination has been made by the Court of Appeal. My lords and my lady, the Court of Appeal dealt with this issue in very elaborate terms. If you look at the decision of Justice Musinga, President of the Court of Appeal, he picked the essential features as the identifying character of the basic constitution. Justice Okwengu located the pillars as the basic structure. Justice Nambuye said it is the constitution itself and what it contains. Justice Kiage said, in his words, the basic structure reminds him of a house. Now you're being asked to reverse the decision of the High Court, the decision of the High Court and of the Court of Appeal by extension. Permit me, before I close that issue, to underscore the jurisdiction of this court. The jurisdiction of this court is set out under Article 163 of the Constitution, and sub-Article 7 is expressed. It says, all courts other than the Supreme Court are bound by the decisions of the Superior Court. What does this mean? It means all those decisions can be put aside, but you, the Supreme Court, ought to make a decision. How then will you make a decision? 10 years ago, when I argued the case alongside retired Judge of the Court of Appeal, Richard Otieno Kwach, he told me a judge is first an advocate and second a judge. A judge is presumed to know the law. Assuming that you are to put aside all decisions that appear conflicting, then you must determine this issue first-hand based upon the law, because you're not a council of village elders. You're not the Sanhedrin to decide ecclesiastical matters. You are in the same position as the Supreme Court of Colombia. You should not be held siege, as was the case in 1985, when Pablo Escobar, whose attempts to become president of Colombia had failed, and he had been removed from parliament, decided to take on the court. What is the extent of the application of the basic structure to the Kenyan Constitution? Let us look at what the High Court and the Court of Appeal said. They located the basic structure in the chapters of the Constitution. They went with specificity to underscore the preamble, the republic, the executive, the judiciary, the commissions, amongst others. Let me just explain some of them. Let us look at the executive. What is the nature of the executive in Kenya? It is pure presidential. What did the BBI bill seek to do? It sought to create a hybrid presidential and parliamentary system where we'll have a president and a prime minister. That was a fundamental change. It amounted to an alteration of the system of government which the people of Kenya had said will govern them. What about the legislature? The system of the legislature in Kenya underscores separation, where elected members of the National Assembly and the Senate cannot be part of the executive through the cabinet. A well thought out entrenchment. What did the BBI bill seek to do? It sought to fuse the executive and the legislature by ensuring that the president has the power to appoint cabinet ministers from the legislature. Again, a fundamental departure from that which the people of Kenya had agreed upon. What about the judiciary? The judiciary is supposed to be independent and accountable. The process towards this entrenchment will only be altered through the primary constituent power. This therefore begs the question, what is the primary constituent power? Where did it emanate from? Is it textualized? The argument put forth by the appellant is that this constituent power is non-existent. It's not textualized. And that if the people of Kenya wanted it to be part of the Constitution, nothing would have been easier than for them to say so. Now, constituent power traces its origin to antiquity in constitutional jurisprudence. You will find it in the written works of John Locke. You will find it in the written works of Charles Montesquieu. But permit me to pick what a recent writer has said about constituent power. A book written by Professor Justice Ernest Wolfgang, titled Constitutional and Political Theory, traces the origin of the constituent power. At page 169, the problem and concept of the constituent power, he says, the constituent power is the basic legal order of the polity. The basic legal order of the polity. But whence does the legal constitution derive this special validity and agency? After all, it does not exist simply by virtue of itself as an irreducible primordial phenomenon. Irreducible